Now, trial by jury is one of Britain's greatest inventions, and now this government is trying to rip it up. Let's be clear, we invented it. It's written into the Magna Carta. No free man shall be imprisoned except by the lawful judgment of his equals. For centuries, the British state has been kept in check by ordinary citizens, 12 people in a jury box. This reform wants to end that. It wants to shift power from the public to the state. Where have we seen this before? The introduction of digital ID. It wants to shift power from people to judges, from communities to officials. Now, this is authoritarianism creeping, quiet, procedural, done under the cover of backlogs. And it was the same with digital ID. They want to bring it in under the cover of safety. Now we know, if you give up your freedoms for safety, you will invariably end up with none. In this case, they blame the backlog. But let's be clear, they caused the backlog. It wasn't an accident. It's the result of decades of underfunded courts, closed courtrooms, COVID pauses, and most importantly, the explosion of either-way offences.
In Britain today, a storm is brewing, and every citizen is feeling the pressure. Legal systems that once protected fairness and justice are now being stretched, tested, and in some cases, manipulated, and according to critics, this is no accident. Tonight, we break down the explosive claims that David Lammy is robbing British citizens of justice, while migrants allegedly exploit jury loopholes to avoid deportation and remain in the UK. Stay with me, the picture is bigger than anyone expected. The discussion begins with a bold statement: Lammy's reforms, intentional or not, appear to weaken the justice system. Commentators argue that under the new legal shifts, migrants facing deportation can request jury trials, a process that can drag on for months, even years, and during those delays, many remain on British soil. Free, settled, untouched. It raises a chilling question: if justice is being slowed down, who benefits, and who pays the price? Here's the mechanism many are talking about: if someone facing deportation requests a jury trial, the system must accommodate, but with backlogs already overwhelming the courts, trial dates are being pushed further and further away. Critics say migrants have learned how to play the system. Legal delays become a ticket to indefinite residency. Not illegal, not accidental, but strategic. And where does that leave British citizens? Here's the hard truth many fear. Trials delayed, criminal cases, backlogged, victims waiting for justice, with no certainty in sight. One case delayed means another sits untouched. A family waits. A victim waits. A community waits. Justice slowed becomes justice denied.
Either way offences are offences that can either be tried in the magistrates, which is quite quick and efficient, or, if the defendant chooses, can be sent up to the Crown Court. These used to be serious cases, but as of 2025, Crown Court backlog is at nearly 80,000 open cases, heading for 100,000. Some trials, believe it or not, are listed for 2029. That's not a functioning justice system. It's a gridlock. And here's the truth that nobody in government will say, is that successive governments have turned far too many low-level matters, either-way matters, into jury-eligible cases. There has been an explosion over the last 15 to 20 years of the category of either-way offences. For example, racially aggravated harassment, racially aggravated criminal damage, racially aggravated assault, or racially aggravated public order. And that also applies to religiously aggravated as well. And the way that that happens is that if you push someone, that is battery. And that is a summary offence tried in the magistrates because it's low level. But if you push that person and say something racially aggravated, religiously aggravated, or anything to do with their sexual preference, then that becomes an either-way offence. And there has been an explosion of this. And invariably what criminals do is they're given a choice whether they want it tried in the magistrates or they want it tried in the Crown Court. And they do choose the Crown Court because they know there's about 3 to 4 year delay. And in that time, evidence is lost, witnesses give up or pull out, and the CPS has to withdraw the charges. All of which of these were simple summary matters. Shoplifting above £200, a fray, some stalking, a whole tier of low-level fraud, and criminal damage up to 5,000 or 10,000 depending on the charge. It is these that are now clogging up the Crown Court, and it's not because the public demanded it, but because Parliament kept inflating maximum sentences for political and ideological reasons. Defendants nearly always elect jury trial when the wait time gives them leverage, especially if they're an asylum seeker or an illegal migrant who is subject to deportation matters. Because if you have outstanding criminal matters in this country, any deportation orders are stayed. And they know that juries are backed up for years. Their defense lawyers know it. A Crown Court trial might take 3 to 4 years. Witnesses, as we said before, will forget, fail to attend, or withdraw. Now, cases collapse because the system can't cope. So they game the system for the delay. And listen, this isn't the defendant's cunning that wins. It's a system that invites abuse because actually the system's broken. And guess who created that system? The government. And now they're blaming the public's right to juries instead of fixing it. Removing jury trials doesn't fix the problem. It merely hides it. They are removing the public, it feels, from justice altogether. You'll no longer have justice in this country. You'll have administration. A system where speed matters more than fairness, where the accused faces the state and not his peers, where the community, the jury, is cut out. Now, this is how authoritarian governments behave, not democratic ones.
People ask, why should British taxpayers carry the cost of endless appeals by non-citizens? This is where the debate sharpens. David Lammy stands at the centre, a man some believe is prioritising political narrative over national security. He argues for fairness, equality, humanity. But opponents insist fairness is being weaponised, that compassion has turned into a shield, one protecting those who would otherwise never remain in Britain. Is this policy, or political theatre disguised as morality? Now the conversation moves to a darker possibility. What happens when juries themselves become compromised? Reports suggest migrants called to jury service may sit on trials involving migration crime influencing verdicts, sympathetic rulings, hung juries, mistrials, delays. A cycle that benefits one side only. If the system is being reshaped from the inside, how long before verdicts stop protecting the public altogether? Online, the reaction is fierce. Citizens say they're tired of being ignored, tired of political figures prioritizing ideology over security. Some are calling it sabotage, others, a slow dismantling of British justice brick by brick. One viral comment reads, "We're losing control," and they're laughing all the way to court. People are not just upset, they're afraid. If Britain cannot enforce borders, law loses meaning. If juries can be influenced, verdicts lose legitimacy. If justice bends for some, it becomes hollow for all. Whether you support Lammy or oppose him, this debate matters, because this isn't about left or right. It's about the foundation of a nation. And foundations don't crumble in a day, they crack quietly, then collapse all at once. So ask yourself, is this system being exploited? Is this oversight, or design? And if the public loses faith in justice, what comes next? This is no small issue, no random glitch, no coincidence. Some say it is no accident at all.